motivation this morning is by Bill Bradley, who says, ambition is the path to success. Persistence is the vehicle you arrive in it. You may have the ambition to be successful. You may have a certain ambition for a particular goal. But what you need to do is keep being persistent. Sometimes it is very difficult when you cannot see the entire staircase. But what I can tell you this morning is keep at it. Be persistent, because persistence is the vehicle that will take you to that destination that you are aiming for. So that's our way of motivation. I'm motivating you this morning. But once, yes, we can go to court. Captain has joined me this morning as we head to the court. Captain, good morning. How are you?
Good morning, Lily. I'm good. Yes,
I'm doing awesome. Yeah. I know, right? Monday, beautiful Monday morning, right? Yeah, but not everybody feels it as though it's beautiful, because exactly. When you don't have a court case and you are not in prison.
Exactly. So, just think about court, how people approach court. You start feeling and having the impact.
And unfortunately, the impact you want to give people, they cannot hear you this morning. So let me take a quick musical break so that his microphone is fixed. Then he can tell us the things that have happened in court and what to expect as well.
They are more busier than even weekdays when you have to come to work and all of that. But this morning, I am taking you to court. And even though I'm taking you to court, I want to start from the Oxford Street. What do you know about the Oxford Street? Have you heard anything about the Oxford Street?
Oh, you know that growing up, we used to hear about the Oxford Street, and we're thinking that
it's a place to have fun.
If I grow,
Oxford Street will be your place to be.
I'll be there 247. And the fact that there are beautiful buildings located or dotted on the Oxford Street,
So sometimes I ask myself, do people really live around the Oxford Street?
Yes, people do.
Yeah, but it's a place to have fun and all of that. So the reason I'm taking you to Oxford Street is what is on your screens.
This building is very beautiful.
Yeah, very beautiful building edifice. So when you get to, is it Dankwa Roundabout?
Yes,
it is the tallest. Circle. Yeah, Dankwa Circle. This is the tallest building you can see. And I'm also showing you the picture of Nana Kwame Pediaku,
popularly known as Cheddar.
Cheddar, or Freedom Jacob Caesar. And the reason I am showing you these videos or pictures is that there's an issue with the building that we just projected. And the reason has become a subject matter of court contention.
Right.
So quite recently, the news broke that the High Court has given a party who went to court the permission to have police presence, police support to go and recover or take over that particular property. And we have seen pictures and videos of some action, even noticed that this particular property had been taken over by a court order and all of that. And over the weekend, on Saturday, I passed there in the evening and the whole place was dark. Yes, the whole place
Contrary
was
to
dark.
how lit it is like
Exactly.
this. Usually that's how it is in the evening.
In the night, the lights are all over the place. But on Saturday, when I used the stretch, the whole place was dark, giving an indication that something had happened there, and based on the order that we have seen. So in relation to that, actions upon actions, it didn't end there. So 21st of July, Director, let's look at the artwork. 21st of July, then we saw a notice, an order from the High Court essentially granting permission for one of the parties to go and take over possession because of an action that has earlier been taken. And the lawyers for Cheddar have now taken an action. They've gone back to the court to say that, look, the order that you have given has some time frame for it to expire. And within that time frame, the party who is aggrieved can file an appeal. And then that 7 days has not elapsed, and that purported takeover has happened. So they have filed some action. But who are the parties in this particular matter? So the parties in this case, Niamano Dudu, and we know that when you talk about the banking sector, it's always there. All the banks that I know have
So he's the receiver.
The receiver in all of that. So the receiver, and then Kola Holdings. And Kola Holdings is actually a company for the owner, Azad, the man who owns that particular facility together with Freedom Jacob Caesar.
So it's a partnership.
It's a partnership.
Okay.
So the two, Cheddar, and then the owner of Azad, they co-owned that particular property. And I'll tell you pretty shortly how they own that property. And of course, that property is being managed by Kensington Residential Partners, or popularly known as KRP1. So these are the parties in the case in relation to that. So let's move and let me give you some background about this particular edifice and why we have gotten here. So what is the background to this case? So Kensington Residential Partners 1 Limited is a limited liability company owned in equal shares by its only two directors. That's Nana Kwame Bediakon and then Azad Kola. So these are the two people who own that particular and equal shares, so 50-50. Now, Oxford Street number 1 Street was developed and it's managed by KRPI, that is Kensington Residential Partners 1. That is the umbrella body that is managing that particular Oxford Street hotel. Then, to fund the development, the company supplemented shareholder company capital with a facility from International Finance Corporation, IFC. So to make sure they put out this particular project, the two of them secured a loan from International Finance Corporation.
So they secured a facility.
Absolutely.
To put out
that particular burden. So that is how we got that facility there. Then the hotel opened in 2019. But what happened? COVID kicked in. And once COVID came into being, it prevented it from trading at the level that it was sufficient to serve the people or the facility in Ilorin, or to be able to get the funds to support or to clear or to service the loan that it has secured. So let's look forward to, let's move on, Director, to what has happened. So while management was engaging IFC to restructure the facility, Azad, who is the other partner, through his company, that is Kola Holdings Limited, wrote to KRPI, and KRPI is the company that is managing the hotel at this particular point, stating that he had personally repaid the loan in full to IFC. So here is the case that the partner now informs Cheddar that, look, the loan facility that we have secured to put out this particular burden, I have paid that particular bill, so that particular loan in full. So now, once I have paid that particular in full, what else do we have to do? That means Cheddar will have to then pay me.
Reimburse.
Absolutely.
But was there an agreement of a sort to say that?
That is what is interesting. So, and demanded that KRPI, that is the body that is managing the company, reimburse Kola for that particular amount. And as directors of KRPI, Mr. Kola was under a fiduciary obligation to inform the company and seek its approval before entering into that profit-making transaction of this kind. So clearly, what the company is saying is that before Kola Azad went to pay that particular loan, he didn't inform the KRPI about the step that he ought to take and how they all agree to have it. So to date, neither Azad nor Kola Holdings, that is the partner, and his company has produced any evidence that the IFC loan was in fact repaid. So that is the contention. You said that you have paid, but till now, they believe that you have not been given correspondence to show that that particular loan has been paid to IFC, and that is where the bone of contention is, and it has become a subject matter of court action and all of that. So they went to court, and the court said that, in fact, before the High Court will even grant that particular order that the police should assist for a takeover, there have been 2 other applications that have been dismissed in relation to the same thing. But of course, the third one is succeeded. Now, lawyers for Cheddar or lawyers for KRPI have now filed a motion at the court, and 2 motions that they filed on Friday. And what are they seeking in relation to what? The first motion that they are seeking, the relief that they are seeking, an order setting aside the purported possession of Oxford Street No. 1 Hotel by the applicant. The applicant here are the Nia Amano Dodu, the receiver, and then Azad Kola Holdings. The 2 of them are the applicants.
But at what point does the receiver come in?
So at this particular, I'm even speaking pidgin.
You see, this is how we are exposed. What the things we say in the newsroom, so please pardon us.
So once it has become important, it is not clear how the receiver came in, but once it is an IFC, it's a financial company, so definitely we need somebody with that financial background to have that asset. We'll see more clarity on that particular. But in relation to what he has filed, the initial applicants in the case are now the respondents in the matter that lawyers of KRPI, they have filed at the court. And the second relief that they are seeking, an order for the applicant, that is the 2 applicants who initially went to court, now they are responding in the matter, Azad and then Mano Dudu, to hand over all assets of the respondent. And the respondent here, in this particular case, is the KRPI, and now they are the applicant. They have filed this particular asking the court to provide them this for the following release and taking in the cost of the purported possession. So if you go to the facility right now, you see an order written on it. They are saying that particular purported should be reversed, and an order for any further orders that the Honorable Court may deem fit and cost against the applicant or respondent for occasioning this particular application. So that is what the director, let's move on. The Cheddar and then the company are taking. But to support his case for why he's asking the court to make those orders, this is why he's saying, this is what he said. He said, at the hearing of the application, counsel for the applicant, and the applicant here is now the KRPI, the management, shall seek leave of the Honorable Court.
Because he has countersued, so now he's the applicant. Now the applicant,
yes. Processes so far filed in this particular situation, that the Honorable Court delivered a ruling in this particular matter in favor of the applicant. So the applicant are the 2 that we have referred to, and now they are known on the 21st of July. That was when the court made the order. That I am informed by counsel for the applicant that verily believes same to be true, that per the rules of the Court of Appeal, there is an automatic 7-day stay of execution and proceedings of all decisions from the High Court, which is appealable, irrespective of whether an application for stay of execution has been filed or not. So essentially all they are saying is that the 21st of July that the court made the order, there's an automatic 7 days from there. So that from 21st, then you have to go to 28th. So if you can do anything at all from that, you to be after 28th. But that did not happen. The day after the court made the order, the following day, they went and took over possession of all of that. So he's saying that, look, if you look at all the processes that they have referred to and all of that, they believe that notice is given to the parties present in court, including counsel for the applicant, on the 21st of July 2026, such that the statutory stay of execution referred to in the paragraph 5 above subsisted up to and including the 28th of July. So if they had to do anything at all from the day the order was given, it should be after 28. Today is 27. So today, he is not even supposed to even do anything about it. So after today and tomorrow, and then despite this statutory 7-day stay of execution, I am informed by the applicant's officers and verily believe same to be true that on the 23rd of July, so from 21st, they went to the premise on the 23rd of July. Being the 3rd day of the 7-day statutory stay, the respondents went to the Oxford No. 1 hotel and wrote on the walls of the hotel that they had taken over possession of the hotel and attached pictures of the pictures, and then to show that that particular process have been referred to. Then that I'm fairly believed to be on this particular point that the respondent went into the company offices from Ghana Police Service and took possession of the hotel and asked all the workers and the guests who had checked in the hotel to leave the hotel.
I can just imagine how I have checked into a hotel and then there's a court order, I'm asked to leave.
That immediately.
Charlie!
Very, very tough and difficult moment at this point. So that is the concern that now the management are raising in relation to how this whole thing has panned out. Absolutely. The 7th, the action of the respondent carried out within the 7-day statutory stay of execution are an affront to the rules and practice of this court, and same ought not to be countenanced by this court. And it went on to say that under the circumstances, this court has the jurisdiction to set aside all execution processes, proceedings, and the purported act of possession of Oxford No. 1 Street by the respondent, and order for the respondent to have hand over all documents and assets back to the applicant in relation to this particular one. And then the second leg of the case. In the second leg of the case, they are asking for an injunction. So they are asking for, if you look at this, so this is part of the affidavit in support, and their motion will be taken on the 10th of August. Okay. And you know that this Friday, today's day is 27, tomorrow is 28, Wednesday is 29, Thursday is 30th, right? Yeah. And the Friday is 31st. The legal year is over. End. But this one will enter into the vacation court. So the vacation court will take this particular motion. So, Director, let's move on. Let me tell you about the second leg of the action, the motion that they have filed, an order of injunction restraining respondents from interfering with possession of the Oxford No. 1 hotel pending the determination of the appeal. So they essentially are telling you that they are appealing against that particular order that was given. And the notice of appeal having been served, they are telling that, look, what reliefs are they seeking by way of the injunction? So look, an order of injunction for the possession of the Oxford No. 1 hotel to return to its status quo, which is to KRPI. Absolutely. So it should go back to the state it was before the order was granted. So that is one of the reliefs they are seeking. An order of injunction restraining the applicant, in this case respondent, from interfering with the possession of the Oxford No. 1 by the applicant in relation to that. And let me give you the concluding part of it. An order of injunction restraining the respondent from interfering with the day-to-day operations of No. 1 hotel, and a further order that the court may deem fit pending the determination of the appeal against the ruling of this court dated 21st of July 2026. And that one will also be taken on the 17th, which is still the vacation court. Absolutely, still the vacation court and all that. So this is the update coming from the Oxford Street No. 1 hotel. And then when the news for now, the status quo remains until that application is heard. So that is what it's supposed to be, because if you read this particular process, it's saying that once the order was given on the 21st, there's an automatic 7-day period that the parties are supposed to wait, so that the aggrieved party, if it wants to challenge, can challenge. But that did not happen. On the third day of the order, they went in and then took over possession and all of that. So they are saying that receiver and absolutely those acts or all other action that were taken within this 7-day period should be reversed to its as it was. Yes, as it was. So, for instance, when I passed there on Saturday and I said that the whole place was in dark, essentially telling you that no work is being done there. So go back, go and do your work. Up until the 10th and then the 17th of August, the place will remain shut.
Until the court
absolutely,
hears
absolutely.
the matter and makes a determination on
For
it.
now, that is what it's looking likely to be like. So we'll keep monitoring the situation, and I will bring you more updates in respect of this particular. We brought it this morning because there were a lot of questions about
and there are a lot
what is
of
happening.
write-ups and conversations and debates on social media, especially. Now let's look at the deepening woes of Chairman Wontumi.
Bernard and Tribu Isiakon. So today, when you go to court, you will not see Chairman Wontumi this way. The videos that we are showing you are videos that were taken previous court sessions. Absolutely. Yeah. So going forward, you will not see Chairman Wontumi come out to come and engage the media. You will not see Chairman Wontumi and his lawyers work together. You will not see that clock it sign from Chairman Wontumi.
We will miss it. We will miss the famous.
Yes, you will miss it. And the reason you miss it is that we do know that out of the 3 cases, one of them is concluded. The Summer Boy one is concluded, and it was very, very hard on him.
Yeah, that was when he was pronounced with a 20-year
exactly. So
now the other legs, the Tano Nimri and then the Exim Bank. Remember the Exim Bank? That's where he made a plea deal, but he was rejected, right?
Exactly. It's not been rejected. So okay, per the update today, they are back in court in relation to the Exim Bank case. And they are coming to give the court an update. Once you file or you request for a plea deal or plea bargaining, there's an automatic 1-month period for the parties to go and sit down and negotiate. And I can confirm that that particular 1-month period has elapsed. And as we speak, the parties have not been able to reach an agreement. They've sent a proposal. The AG also gave them a counter proposal, and they have not accepted that particular counter proposal. So what it is now is that today...
Do we know what that counter proposal is?
We are here to get details. So if they had agreed, they'll come to court and tell the court that this is what we have agreed on. Both of them will sign, and then it's adopted. And the Chairman Wontumi plea will be taken, and in this case, he will have to admit to the charges that have been leveled against him. And all of them will be part of the plea deal.
This is no good for Chairman Wontumi.
So today, before Justice Halima El Alawabdu Bassett.
So that's a different judge?
It's a different judge. Okay. I mean, all the 3 cases, different judges.
Okay, who is sitting on the Tano Nimri case?
So for the Summer Boy one, Justice Audrey Kokuvite.
Yeah.
The Tano Nimri one is Justice Ruby Aiti.
Okay.
And then the Exim Bank one is Justice El Alawa Abdul Bassett. So today, he's before Justice Alawa Abdul Bassett, Halima, and so we'll know as to whether he'll make a physical...
Three female judges.
That's it. As to whether he'll make a physical appearance in court is one thing that will be in court to give you an update on that.
I mean, because this is a plea deal, maybe his lawyers will be there.
It's more likely. Yeah. It's more likely. But you never know. So many things happen in court.
Sometimes the countenance of the accused also counts in court.
In fact, it's supposed to be in court because it's a criminal case. And as a criminal matter, you have to be in court. The only reason he may not be brought...
When the court grants you leave.
Yeah, the only reason he may not be brought is when the officers come to have a special challenge. But once you don't have a special challenge, as an accused person, every day and every now and then when your case is in court and you are in lawful custody, you have to be present in court. So definitely, this case is not a civil matter, and Chairman Wontumi will have to appear in court and all of that. So we'll be in court to follow and then monitor what will be happening in relation to that. Whether indeed maybe there's a U-turn that you have now accepted the deal. Yeah. Then we'll know what will happen from there. But today, keep an eye on this particular one. The Exim Bank one, Chairman Wontumi is back in court. For the first time after his 20 years incarcerated. For the first time in this case, because for the first time he has appeared in the Tano Nimri one.
Yes, that was last
after
week.
His conviction.
So today is actually a week since his conviction.
Today is a week. It's a Monday.
Yeah, today is Monday. So
7 days.
It's been a week since he was incarcerated in the some medium prison. So today he will celebrate his 1 week anniversary. 1 week. Yeah.
So that is
not a celebration.
It's not a celebration.
Oh dear. You know, they always say that until the law catches up with you.
You don't know how the Ghanaian law works.
Yeah. And you will not understand the essence of freedom.
No.
Yeah. This one, we're not talking about Freedom Jacob Caesar.
No, no, no.
We are talking about what means freedom.
Exactly. So freedom is very, very expensive. So if you have
Trust me.
freedom, try and protect it.
And protect it
Yeah,
at all costs.
protect
But let's
it,
look at some of the cases that have been listed under the Operation Recover All. So that's the Professor Christopher SkyTrain case. Yeah.
So the High Court, presided over by Justice Audrey Kokuvite, has made an order. It looks like Justice Kokuvite is
It's becoming gradually popular, isn't it?
It's a tradition within the judiciary that, you know, at some point in time, there are some high-profile cases, and we keep mentioning some particular judges almost every day. It happens. Justice Lydia Osema, if we got to a point, it was a name we were mentioning virtually every day when we are talking about the high-profile cases. Justice Fiasewa Saribotri, at some point in time, was a name we were mentioning virtually every day on this particular set. Justice Clement Hunionuga was a name that... So, depending on the action, the cases that come, and the specific judges that come, and because it's a case of public interest, every now and then we keep mentioning their names. So today, Justice Audrey Kokuvite will be hearing two applications, in fact, from the lawyers of Professor Christopher Miekonfi and then Solomon Asamoah in relation to the SkyTrain project. And the reason is that the High Court has found as a fact that a prima facie has been established by the witnesses that the prosecution called, and therefore the accused person should enter into the witness box and provide answers to the charges that have been leveled against them, and how the $2 million was expended and all of that. They say that, look, the evidence adduced by the prosecution witness in the state, it doesn't meet the threshold for them to be called upon to answer. So they made that, and once the court dismissed the submission of Noki, they said that they are challenging that at the Court of Appeal. So they want the High Court to stay proceedings. So as we speak, they have not filed their processes, their defense, witness statement, and all of that. They have not filed. The reason is that they say that they are challenging the order at the Court of Appeal, and they want the court to stay proceeding. So today they'll move that particular motion. The two of them will move their respective motion, and the judge will make a determination. But of course, the Attorney General, through the Deputy Attorney General, they are opposing to that particular request that the two have filed. We'll be in court to monitor what will come of it.
And then GHOne also back in court.
Yes. Kwabena Edubuahin, Angela Ejie-Boateng, they are back in court. And today, their lawyers, led by Samuel Atachina, will continue with further cross-examination of the fourth or the last prosecution witness, in this case, the investigator, Eugene Akpo, is in the, with Cromwell, Frank Marshall Cromwell, instead, an official from UCO, is in the witness box, and then the lawyers will subject him to cross-examination. If possible, maybe they may conclude. But if they do not...
So that is a prosecution witness?
Yes, that's the fourth and the last prosecution witness. So know that the driver of the accused persons have come to testify. The director of finance, Madred Edith Adumwa, has come to testify. Madred Donko, who has worked with the accused person, have come to testify. And now the investigator, Frank Marshall Cromwell, is also testifying. It's in the witness box. So today, before Justice Francis Apangabo Achibonga, we'll see more updates on this case.
Okay. Captain, thank you. Thank you. I'm sure there are other cases that you chance on as you head to court. That should do for court today. I take a break. When I return, my guests will join me for the breakfast with you. Today is the Battle of the Esquires. Stay with us. Welcome back to the show. This is still J today here on GHOne TV, and I am Lily Mohammed. Let's bring you sports now. I know it's been a while that you saw the man who's always outside come inside. So today he's here. Jones, how are you? It's good to see you.
I'm all right. It's been a while. It's been a minute. You know, the American vibes.
Oh, you're rising,
But who are you supporting this year's World Cup?
Oh, aside Ghana, Spain.
Oh, okay. So you were not left in pains.
Of course.
I said bars.
Bars. Let's head to the sports world. Okay. Let's look at a few things that you talk about this morning.
Well, we'll start with tennis. And there was a youth under 15 championship held in Ghana. You know, Boteman, although a lot of people are saying that Charlie Boteman is being left to rot, weeds are growing up, but still it's being used.
Has it not been left to rot?
Well,
what's the current state of it?
You know, it's in between now. The Boteman Sports Complex should be managed by the NSA, and it's the land of the University of Ghana. So they are in between trying to find who can actually really manage the place very well. And we know with the track record of the NSA, Charlie, it's not been too good. So sometimes if you leave it in the hands of private entities like the University of Ghana, they can manage it better. So I know that plans are underway to make sure that they hand it over to either the NSA or the University of Ghana full time. But the tennis championship happened there, and these two young, wonderful athletes won gold for Ghana. And Ackley is a young man in there, and they made sure. In fact, they beat Tunisia by 3-0. And for the very first time since 1964, Ghana wins gold in a championship like this, and that's big for us. And congratulations to these two. We hope that we build on this transition. At the last World Cup, we saw that the Spain team had a team in 2015 that was coached by the same coach, De La Fuente, and they transitioned to become champions. So we hope that just like this under 15 athletes, they can also go beyond what they've achieved now and become champions later in the world stage. Now let's move to Accra Suffolk, your darling club. You know they've sacked their coach.
Yeah.
So this is a new coach, Obroni. I don't know.
We are hopeful.
Yes.
Hopefully he takes us better heights.
Yeah, hopefully.
Like the Black Stars coach is doing.
You love the Black Stars coach?
I do.
I see. You don't like Otuado?
Oh. But you know, I was one of the key proponents of Otto Masco. So
You people.
it is not about being black.
Yeah.
If it's that, I am very biased towards black people occupying certain key positions. But if you are not performing, Charlie, this life is based on merit. Even though meritocracy is a myth, but anyway.
Anyway, so Neboska Kapoor is a new coach of Accra Suffolk, and he's a former coach of Midiama. So he's going to be taking the helm of affairs. 2 years contract.
What was his stint with Midiama? What were the results?
It wasn't bad. He did well. No, he actually plays some very good football. Okay. And he's been on the Ghanaian scene for some time now. So it's not like
he understands
exactly.
Okay,
exactly. He plays some good football, and I think it makes sense. It's a good reward for him. Accra Suffolk have some new assistant coaches, the likes of Adamu and the goalkeepers coach, all in there to make sure that the change really happens for Accra Hearts of Oak in there. Now,
so Accra Suffolk has seen a reset, eh?
Yeah.
Because the man he's still in Ghana and he's been brought back to another Ghanaian team, right? Yeah.
So reset everywhere. Well, let's move to Glasgow.
Yeah.
We're gonna move to Glasgow.
Goodness.
Yeah. You know what I'm saying, bro? That's what's up, man.
Okay, let's talk about the Commonwealth Games.
So the Commonwealth Games started last week, and Ghana obviously part, and we saw swimming happen. So that's Snowden. He made it to the next stage of the competition. I mean, she's going to be in action today as well, but congratulations to her. And we also saw boxing. Now, really interestingly, Mohammed fought boxing earlier, and defeated the opponent under 1 minute. Knockout, proper knockout.
Yeah.
You get to see the video.
There's something about the Mohammed name, you know.
Yeah. So that's Ahmadu Mohammed. Under 1 minute, he beat the guy. So he is qualified to the next round of the competition in there as well. But let's look at what will be happening today for Team Ghana. Quickly run you through the lineup for Team Ghana, and we obviously will see Emmanuel Boateng weightlifting final today, 71 kg, and then athletics 100 meters heats. Saminu Abdul Rashid, there's Benjamin Azameti, 100 meters today as well. Isaac Bocho, 100 meters. And we'll see short put final, Zinabu Issa. She's an African champion. She's also going to be there. And 800 meters, Abigail Abugri would also be in action today. Deborah Champong, 100 meters heat. Ramatu Kwei, 51 kg. Boxing for Ghana today. There's boxing for Ebenezer Ankara, boxing for Precious Nete, and then boxing for Desmond Papo as well. We have swimming, Nubia Ejay in the 50 meters backstroke, and then para swimming for Promise Aheto as well. So these are the men and women making a battle for Ghana today at the Glasgow Olympic Commonwealth Games, not Olympic Games, Commonwealth Games. Well, let's head finally to WAFCON, where the women's 2026 African Cup of Nations. And yesterday we saw the first game was between Algeria and Senegal, and then Algeria surprised Senegal, beating them by 2-0. So they first, have the first point, 3 points. That game was at 5 p.m. And then we also saw yesterday the opening ceremony. Yeah, the opening ceremony happening between Kenya and then Morocco. Morocco also beat Kenya 4-0. Yes, host nation Morocco making a statement in there. And then Ghana are going to be in action on Wednesday. But today, we'll see there are some games coming up today. We'll see South Africa take on Tanzania. There is La Côte d'Ivoire up against Burkina Faso. We're rooting for the Black Queens. Wednesday, we're going all out for the Black Queens. So the 2026 WAFCON has begun. We'll give you all updates on the game at exactly 1 p.m. today as well. Well, Lily, that's all for sports today. We'll be back with more. We are back, I promise you.
It's interesting the way he says it. I promise you. Okay, thank you, Jones. That's it for the sports chat. I take a break, and then my guests will take their seats for the breakfast review. I told you it's the battle of the Esquires. Stay with me. Yeah, welcome back to the show. This is still GH today here on GHOne TV. My guests have joined me for the breakfast TV, and this morning I've been joined by two lawyers. Ross Owusu Esquire is a member of the NPP Legal Directorate, and Bernard Bediakubedu Esquire is the Member of Parliament for the Good People of Akutia. Good morning, gentlemen. It's good to see you.
Good morning.
Good morning.
How are you?
I'm fine. I'm
This
fine.
is your
I'm doing
first
very
time.
well.
You're welcome to
This
our
is
show.
this is my first time in these studios, and I'm
Yes.
happy to be here.
It's good to see you.
Yes, good to see you too.
Council, how have you been?
Well,
I see that you've been doing a lot of talking on the Wontumi case.
What can you do? We are doing our best at least to explain the issues to the people as far as our understanding goes. But how have you been too?
I've been awesome.
I can see.
I know, right? Anyway, since I touched on the Wontumi, I know we'll talk about budget because budget was read last week. But let's touch on Wontumi because even though he's back in court today, it's not on the same matter. Today he's back on the Exim Bank matter. But let's talk about him and his incarceration and the concerns of the minority and the NPP. They call it a political imprisonment, and they say that the judge was in an ambulance mode, especially his lawyers. I heard one of his lawyers, Samuel Atachia, say that. Bernard, you have raised a number of concerns and trying to answer.
I thought they raised the concerns.
I mean, the concerns they raised, you have equally raised concerns that, well, is neither here nor there. And the fact that, well, there was evidence, circumstantial evidence.
Okay, so good morning to you again and your team, then my brother, and our viewers as well. Yes, what it is what it is. At the moment, the judiciary, at the moment, is done with its work unless somebody decides to go up, which is the appeal. We've heard all kinds of things. We've assembled over 20 grounds, whatever. I mean, for that, it is his right. Even if it is 100 grounds you intend, you can raise it. And the good thing is that appeals are heard on notice. So surely the state represented by the Attorney General would also be there. And so if they intend appealing, they are right. Nobody can take that away. And in fact, that's the way to go. Of course, I remember Atoforsen and others in a case of a submission of no case, the trial judge dismissed that application. Atoforsen and others didn't hold a press conference. You see, this is the challenge I have with our people. I mean, the MPP. Their lawyers applied to the Court of Appeal that they disagreed with what the learned trial judge had done. The Court of Appeal saw reason and vacated the ruling of the trial court. So that is how our system runs. If anything is done and you disagree, I mean, at any trial court, you go up there. Now, don't forget that this same case, when Chairman Wontumi, when the state made their case in court and he was called upon to put out his defense. He disagreed and filed, normally we do it. He filed a submission of no case application to have the matter. He thought that the state had not made the case strong enough for him to even respond. The court disagreed with Chairman Wontumi and ordered him to proceed to give his defense. They appealed, don't forget, they appealed at the Court of Appeal that they disagreed with the court and that the state had not made a case strong enough to, warrant his defense. And the Court of Appeal also disagreed with Wontumi and said there is a case for you to answer. And so we are back here. For me, except somebody tells, at least with my few years of practice in our courts, I do not know what has actually gone bad or gone untoward in law in terms of the procedure. And this talk about political persecution, political prisoner, I don't know, because take your phone and Google who a political prisoner is and persecution. Tell me the rules of court that were breached. Tell me how his fundamental human rights were breached. Was one to be not coming from home, even though the court had every power to even hold him, just as we have ordinary alleged criminals who come to court from the prisons.
A political prisoner is someone locked up because of their ideas, speeches, or peaceful groups rather than a real crime. Global bodies and human rights groups look at specific signs to separate these cases from regular law breaking.
You've done your viewers so much good this morning. So what do you make out of this statement, political prisoner? Is it about what he believes in? Is it about something he did politically? For which reason? Was he not charged under our laws? Under the Minerals and Mining Act, Act 703. Was he or was he not? Throughout the trial, was his fundamental human rights breached? So why would anybody? Is it the case that MPP only understand justice to mean innocence? Is that what they believe in? That it is only when somebody has been, tried and acquitted. That's when they believe that the person was not, or the person, there has been a fair trial. Is that what they believe in? Is that what they, and if it is the case, then go back to their record. Why did they try a number of people? And even when the court even said that this Atuforcing matter I'm talking about, Godfrey Dame gave an indication. He released a statement, and these are the same people who blame the Attorney General for press conference. Check Godfrey Dame. He released a press statement. That's not what lawyers are taught to do. He released a press statement that he was going to appeal the decision of the Court of Appeal. I don't know what has become of that decision. But if you Google, you will see. And he gave some words. He even said all kinds of things people thought that were too harsh to the judiciary. We remember in this country. Now go back. Let me go into GHOne and some of the things I've heard. My dear, first and foremost, having established, and nobody has ever said anything on that there wasn't a fair trial. I don't know whoever would quote any rule of law of the courts or of our statute which was breached. We have heard often that there was a case that was made for a referral to the Supreme Court because they believed that there was no punishment attached to the offense of Section 14
and 99(2).
And 99(2)(b). I'll be shocked if anybody adds 99(2)(b). I'll deal with the 14. But what do we have at 99(2)(b)?
Okay, 99(2)(b). A moment. Okay.
99(2)(b). It's good you are prepared. Very good. So you can be a good arbiter. 99(2)(b).
Okay. A person who, without a license granted by the minister, undertakes a small-scale mining operation contrary to Section 1, or acts in contravention of provision of this act in respect of which an offence has not been specified, commits an offence and is liable on summary conviction to a minimum fine of 1,000 penalty units or to imprisonment for a term not more than 3 years or to both.
So, and somebody...
I should think you are not reading the amended.
Oh, the amended.
No, you were not reading the amended.
Okay,
so you should.
Okay.
The 99.
Yeah, okay, I've actually marked it here. 2B. A person who, without a license granted by the minister...
That's A. You are reading
2A. I beg your pardon. So
it's good. Read from A.
Without a license granted by the minister, undertakes a mining operation contrary to the provision of this act. B. Acts or instigates, commands, counsels, procures, solicits, or in any manner purposely aids And this was where the judge ruled on.
Don't worry,
Purposely
I'll
aids,
deal with that one.
facilitates, encourages, or promotes any acts in contravention of a provision of this act in respect of which a penalty has not been specified. C, or contracts a non-Ghanaian to provide minor support services, commits an offence and is liable on summary conviction to a fine of not less than 10,000 penalty units and not more than 15,000 penalty units.
So you see, I'm surprised, my dear. Look, who would ever say that punishment is not attached to B? Read it carefully. He said all.
But this one, it says contracts a non-Ghanaian.
No.
Okay,
hold
so
it.
there's either or. Okay.
If you understand, this is basic.
So
This
subject
is
to
so
interpretation.
basic. So it's not subject to any interpretation. This is basic. He said has not been specified or.
Okay.
So it is either this or that. And it gave a punishment for all.
The punishment is not more than 15,000 penalty.
So how can you
units and
say
to a
there
term
is
of
no
imprisonment
attached punishment for B?
of not less than 15 years or not more than
How can
25 years?
anybody ever think that there is no attached punishment for B? Because he said, or if you do this or that, this is the punishment. So the punishment beneath affects the earlier aspect of this whole thing. Okay. So if you say that if you take A or B, this is your punishment. We are talking about both. Is that not the case? The punishment affects both. So how can anybody say that there is no attached punishment here? In any case, as lawyers, we know there are copious authorities. If you want to raise any point of law in terms of a constitutional provision, you must even raise it timeously. Because if you read Article 130, it talks about where proceedings are being held. Proceedings. At what point was it? Read Article 130.
I sure will.
So, first and foremost, it is not the case, as far as I'm concerned, that there is any problem with the wording here.
Okay.
There is an attached punishment. In any case, procedurally, you have to raise it. Read 130 of, that's what they refer to.
Article 131, subject to the jurisdiction of the High Court in the enforcement of the fundamental human rights and freedoms as provided in Article 33 of this Constitution. The Supreme Court shall have exclusive original jurisdiction in A, all matters relating to the enforcement or interpretation of this Constitution. And B, all matters arising. You want me to read Article 130? Okay. Okay. Where an issue that relates to a matter or question referred to in Clause 1 of this article arises as any proceedings in a court other than the Supreme Court, that court shall stay the proceedings and refer the question of law involved to the Supreme Court for determination.
So throughout the proceedings, what was the matter that was raised for the court to stay proceedings to refer the matter to the Supreme Court? Throughout the proceedings. This was raised at the time the new council filed a submission. In fact, it was in the written submissions. When we were done and I was awaiting judgment. So at what point, and who discussed that? Because you see, before you refer a matter to the Supreme Court, there must be some, what do you call it? There must be some conflicting interpretations over a provision of the Constitution. Do you understand? There must be some conflicting. You say you understand it this way. I also say,
so
where did that happen? Throughout the proceedings, where did that happen? Tell me. They should produce the proceedings where one was saying his understanding is this and another was saying something else. It never happened. It never happened. We were done. And you were supposed to write a written submission based on the proceedings. What had happened?
Transferred, yeah.
That is what, you were requested to do. Then you came to raise your own, that there is a certain provision you want the Constitution, the Supreme Court to interpret. In any case, let me also give this in the same, you understand, you would know that, you see, when a matter is referred to the Supreme Court for interpretation, like I said, there must be conflicting meanings. You are saying, assuming, I don't even admit that, but assuming it is even the case that you think that a punishment was not attached to a particular offense, which offense Article 19, granted without admitting that it happened, What we are saying is that you are then, and that is what the judge said, you are questioning the manner in which Parliament, drafted a law. You are not seeking an interpretation. Where are the rival meanings? You are saying that there is no punishment attached to this particular offense. Do you understand the point I'm making? Yeah. So it is not a matter of rival meaning. It is questioning the drafting or the law that Parliament passed. That is not within the remit of two. Because with two, it is saying that during the proceedings, that I understand that I should be given a fair trial within the remit of the constitutional provision. And the other side also say, my understanding of fair trial is that you shouldn't be admitted to bail. Then we should go to the Supreme Court to settle the matter. But there wasn't any conflict. There weren't anything like that. You are rather at your closing or during your closing address or in writing your closing address, you then brought in that this one has a problem. And the problem is that according to you, there is no punishment attached to it. How is that a constitutional interpretation? You are questioning, and you have that power, you have that right to question it, but the mode is not through this.
Okay.
The mode is not this. This doesn't come in.
How
they should know. I'm not to tell them. The mode is not.
But you're a lawyer.
But you see,
for the purposes of people listening this morning,
the matter is even they intend appealing, and I'll be shocked if they claim they don't know the mode. This is not the mode. There are no rival meanings, stricto sensu here. So for me, that matter, I don't see it. Now, they have also made mention of certain things, including the fact that they claim there is some assignment of a sort, and that because of the mention of assignment, it ought to be written. I don't know where they got the I don't know where they got that from, actually. Because you see, my dear, you know what? They refer to assignment, and to the extent that I've heard some of their lawyers even say that assignment, as they understand, we should seek the interpretation or the meaning of assignment from another act, which is the Lands Act. Who does that? Did we all not go to the same law school?
But the assignment is clearly written in Section 14.
No, but so what's the definition there?
It says...
There is no definition in that law. Let me help you. Look, you come through. There is no definition of the assignment in the Minerals and Mining Act.
That's true.
There is no definition. They didn't interpret it. But in the Lands Act, they did interpret it. Go and read the Lands Act. If you have it, the 2019, even though I personally feel that it doesn't even come in because that's a different act. Okay. It is not a universal law. It's not a constitution that we draw.
It deals specifically with land.
With land. So you can't go and take an interpretation in the Lands Act and apply it in the Minerals and Mining Act. It doesn't happen anyway. These are different laws. It is not a universal law where, for instance, the Constitution, if you seek an interpretation in any act, you should seek the mother interpretation from the Constitution because every law is subsidiary to the Constitution. But it is not so with different acts. They have the same... Because even assuming it is even the case, and I will tell you why I don't even subscribe to that. But you see, even if it is the case, look at the procedure in procuring the so-called assignment from both laws. They are different. Here you go to the minister for whatever. It is not so with the Lands Act.
Yeah, you need to write
with the Lands Act. It never. If anybody has the Land Act, there is an interpretation of assignment. It never said that it ought to be written. It never said it ought to be written. But you see, read that aspect or that law, and you understand. I don't know why they are doing. Whatever they are doing is pure politics. Nothing law. See, if you read the Section 14, is it the 14 or the 19?
14, the assignment of mineral rights.
Yes.
It says a mineral right shall not in whole or in part be transferred.
Hold it. So then what is also the meaning of transfer? Should we go to the Black Law Dictionary to ask of what transfer? Why? These are words that are used, not the legalese words of assignment that you should go and find from anywhere. This is why it used the word transferred, assigned, mortgage, and then all that. So if you are not comfortable with the assignment and you want to be legalese too much with the assignment, talk about transfer. Because that is what the law says.
Okay.
But it never said anywhere that it ought to be written. But is it the case that GHOne to me handed the concession to them or that land to the gentleman?
He admitted.
They admitted that he did. Do you know him? You said yes. I took him there. He is doing something illegal. You are saying, well, I took him there, but I didn't ask him to do that.
I asked him to do reclamation.
We didn't even expect you to tell us because you said you are not guilty. So we didn't expect you to say you asked
But
him.
he was not able to tell whether the guy was a mining support service worker.
No, but he said, of course, because the law, even with a mine support worker, is also clear that you need permission from the minister. So that aspect, he brought it in, and the minister, and then the court said that even if it is the case, you are still wrong because the gentleman didn't have the permission from the minister. But that is not even the case. The place was mined. You claim, can you imagine that you went to procure some earth-moving machines for the gentleman, including excavators? Do we use excavators to reclaim? I am from a mining site.
Okay.
Well,
yes, you're from Akutia, yes.
If you intend reclaiming a site or a land, you use bulldozers. You use graders and those things. You don't use it because excavators rather day.
Okay.
So we are not kids. And that is why circumstantial evidence comes in. Initially, they even said that the judge shouldn't have used later, they backtracked and then they said, oh, circumstantial evidence, but it didn't really warrant. Look, every lawyer knows it. About 99% of all crime are resolved through circumstantial evidence. It is law. And it must lead to an irresistible conclusion that you are the one that did it. So if, according to judge, he evaluated it and came to this conclusion, you may disagree with him. But it doesn't take away the power of the judge to evaluate the evidence. And evidence is not just paper. How many witnesses did you call to corroborate your claim that you didn't? Look, and the judge said there wasn't even any witness between you and the gentleman because at that point, a claim has been made. The gentleman who was arrested is saying that you took him there. So the onus was on you to prove that you admit that I took him there. The gentleman was doing something illegal. And you are saying that it is the judge or the court that should have been able to resolve that matter, that indeed the gentleman did what he did. He is saying that, yes, I mind. The gentleman is saying that he is a small-scale miner. He is not an agriculturist. He went there to mine. And you are saying he went there to reclaim. Did you give him money? Did you pay him? This is what, because you see, it is based on, circumstantial evidence is based on the fact that has been put out there. There is no direct evidence. And that is what circumstantial evidence is all about. So the judge should be able to resolve the matter by listening to both parties and at least making something out of it.
Okay.
So it is not the case that, well, there are other things, but you, for now, let me leave it.
Absolutely. Let me hear him and then come back. Ross.
Yes.
You've heard your colleague lawyer extensively.
It is the case of the New Patriotic Party that laws of these countries ought to be respected. And it is also the case that we believe that illegal mining is not an activity that any Kenyan, including an MPP person, should be involved in. It was in our time that the sentencing regime was amended and was given a more safer punishment. But what we are against and what we are complaining all this time is selective application of the law when it comes to persons that are deemed to have infracted the law, persons that are deemed to have gone contrary to the law. There should be equal application to those people. It is the case that the NDC own Attorney General, i.e. Dominic Aini, had the occasion to refer some personalities in the NDC to the Economic and Organized Crime Office for investigation since September last year. And for purpose of clarity, I must mention that the national organizer of the National Democratic Congress, Mr. Joseph Yamin, has been mentioned. And the third vice chairman of the National Democratic Congress, Yakubu Abanga, has also been mentioned. And you will also realize that there are members of parliament set up. Who have equally been mentioned? The Member of Parliament for Awin, Member of Parliament for Afwano, Southeast, and some others have been mentioned to have been engaged in illegal mining. Why is it the case?
Was not on illegal mining, was it?
But that was the narrative they were pushing until exactly.
Yes,
you see,
and
is there any
explain.
the judgment he was copiously quoting from? Is there any line or paragraph in the judgment that points to Mr. Woon to me engaging in illegal mining?
Here.
That is not correct, and I challenge him to point that to me.
I will explain to you.
And you don't need to explain to me. You need to point to me in the judgment where it is stated that Mr. Woon to me is engaged in illegal mining.
Counsel,
please, and I'm building my point.
I have the judgment equally here, so you can. When I come back to
this
you,
banter is really my line of thought. I think I should be allowed to proceed.
Please go ahead.
We see Chairman Woon to me to be a political prisoner. One, because of the lack of political will by this current John Dramani Mahama administration to prosecute one of their own. In fact, please, I think I should be allowed to flow.
Please go ahead.
In fact,
apologies.
In March this year, when John Dramani Mahama himself met organized labor, his position was that members of his administration were involved in illegal mining. And this is a public knowledge. If you do a simple Google search of this, it will come out. You understand? Now, let's come to the substance of what he mentioned. Article 1911 is very clear. It's a constitutional dictate, and it is very, very clear.
Okay.
There are case laws that have been developed to support the position of the MPP in this appeal that we are pursuing. And in fact, let me pause and say a very good morning to His Excellency Dr. Mahamadou Bawumia, the flag bearer of the New Patriotic Party. I was in a meeting on that fateful Monday when that meeting had to be brought to a hold. You know, we had to hold that meeting because the flag bearer directed that the legal directorate meet with him to explain the judgment that was handed to Chairman Woon to me. And a decision has been taken by the party together with the flag bearer that this judgment handed by Justice Audrey Kokuvite ought to be appealed. And we have no doubt in our mind that on appeal, this judgment will be reversed.
Okay, so the 1911 you mentioned,
Yes,
no
when you
person
read-
shall be convicted of a criminal offense unless the offense is defined and the penalty for it is prescribed in a written law.
Exactly, precisely. And if you look at the wording of Section 14.1 and Section 99.2b of the Minerals and Mining Act 703 as amended, you cannot come to the conclusion that specific, and see, the wording of the Constitution is very, very clear. Very, very clear. No person shall be convicted of a criminal offense unless the offense is defined and the penalty for it is prescribed in a written law.
Sure.
You cannot tell me that Article 99, Section 99.2b of the Minerals and Mining Act as amended specifically prescribed offenses, the punishment that was handed to Chairman Woon to me in relation to the offenses. That is not correct. And I will come to Article 130, 131 and 2. And let me read the 131. Subject to the jurisdiction of the High Court in the enforcement of the fundamental human rights and freedoms as provided in Article 33 of this Constitution, the court shall have exclusive original jurisdiction in all matters relating to the enforcement or interpretation of this Constitution, which Article 1911 is one of them.
Okay.
B says that in all matters arising as to whether an enactment was made in excess of the powers conferred on Parliament or any other authority or person by law or under this Constitution. Now, 2, when an issue that relates to a matter or question referred to in Clause 1 of this article arises in any proceedings in a court other than the Supreme Court, that is the operating word, in any proceedings.
Sure.
I don't know where Honorable is coming from by saying that when it is time for addresses and that the time to have triggered this particular provision was passed. And he doesn't see why the MPP is now purportedly trying to trigger this provision at the addressing stage. The Constitution is very clear, and you should read it again, that where an issue that relates to a matter or question referred to in Clause 1 of this article arises in any proceedings, at the addressing stage, was it not still at the pendency of the case? Was judgment given at that point? The answer is no. So the New Patriotic Party and the lawyers of Chairman Wontumi was clothed with every constitutional right to raise that question, and the matter ought to have been stayed for this particular provision which is being alleged to, i.e. Section 14.1 and Section 99.2b, to go to the Supreme Court for interpretation. In any case, it would have enhanced our jurisprudence when this matter had been referred to the Supreme Court for the Constitutional Court to give its interpretation. We did not see that, and we find that to be a grave miscarriage of justice on the part of the trial judge. Again, you would realize that before this judgment came out, and I must place on record that the MPP is never attacking or criticizing the judge who handed the sentence. What we are criticizing, which is within our rights and is allowed by law, is the judgment that she handed. That is how come cases are tried at the trial court, and it goes on appeal, and sometimes it is what? It is reversed. So the fact that we are attacking the judgment doesn't mean we are attacking the person of Justice Kwokuvite. We are not doing that. The narrative out there before this judgment came out was that Chairman Wontumi was engaged in illegal mining. Was that not the case that was out there? In fact, when this judgment came out, some elements in the NDC, even still today, and which Honorable here has even mentioned that the man was engaged when you were trying to tell him that he was not directly accused of illegal mining. He mentioned that
you bring me in and you are missing.
No, hold on. You mentioned. I was in this studio.
Don't worry. I'll give you the chance.
You mentioned that. You mentioned, please.
What, please?
You mentioned.
You don't misquote me and say please.
No. You mentioned it.
Don't worry. That's why you're here. You will have a chance to rebut.
He was charged for illegal mining. He mentioned it. And it is clear on the face of the record. It is clear on the face of the judgment that Chairman Wontumi was not directly.
You are now using
that was not that. Of course, the court did not come to a conclusion that Chairman Wontumi was engaged in illegal mining. That is how come the court had to rely on circumstantial evidence. And the court rightly quoted the case of Dua versus the Republic. Yeah. And the case of Dua versus the Republic is very, very clear on the position which the court ought to take when it is applying circumstantial evidence, that whatever the court is applying, the allegations that has been alleged should lead to an irresistible conclusion of guilt of the accused person. As we sit here, can we directly say that Chairman Wontumi was guilty for any illegal mining? We can't. In fact, the persons that were actually involved in the illegal mining, they were used as prosecution witness by the Attorney General. You understand? So indeed, if the state is minded in fighting illegal mining, why would they? And I've heard Justice Remsai, the Deputy Attorney General, who led this prosecution in court, saying that in case Chairman Wontumi was convicted on his own evidence, and that the state was not the one that even proffered any evidence to that effect, and it was the own evidence of Chairman Wontumi that convicted him. How do you proceed to court as an Attorney General of this country without any shred of evidence, and you have to even rely on how do you call it?
The witness statement of the prosecution of the
accused to prosecute your case. So it means that they even set out to actually investigate Chairman Wontumi and got nothing, and decided to rely on his people, the PW1 and PW2, to actually make their case. And this is a very gross miscarriage of justice, which we in the NPP, we are alluding to, and not in the person of the justice that handed the sentence. And we have every right to mention that Chairman Wontumi is a political prisoner, and it depends on how you interpret what political prisoner is. But
so what is your interpretation of?
From my interpretation of who a political prisoner is, when a government comes into power and has made its mind, and Chairman Wontumi, it is popularly, everybody knows this, that the government of John Dramani Mahama has singled Chairman Wontumi out for prosecution, and they have achieved that, and they have done everything.
On what grounds?
On the grounds, mind you, this case of Chairman Wontumi did not start now. It started in 2013 when his excavators and all that were bent. You understand? So this is a man they have targeted right from their time in opposition to the time they came to power. And it has been evident and clear that before they even proceeded to put the man before court, they had no such evidence. And it was at the course of the trial that they had to use the other people that they have put before the court to actually prosecute Chairman Wontumi, which is clearly not right politically. You understand? So we insist that Chairman Wontumi was targeted. We insist that Chairman Wontumi had done nothing untoward when it comes to illegal mining, and we insist that on appeal, this judgment is going to be reversed.
What are you appealing on? Technical grounds?
No, we are appealing on the face of the judgment.
Okay.
You understand? Chairman Wontumi was convicted on 2 key provisions of the Minerals and Mining Act. And we are saying that these provisions do not support the conviction and sentencing that was handed to Chairman Wontumi. Okay. And that the judge, and I don't know what is the difficulty in this, of the judge referring this matter to the Constitutional Court to actually interpret. If this had been done today, I'm not sure MPP will be citing Article 1911 and Article 132 to hinge our appeal on. You understand? So I think the judge equally did not do a lot of good to us, did not develop our jurisprudence by not heeding to the call of the defense lawyer to refer this matter to the Constitutional Court.
Okay. Counsel.
So, first and foremost.
Which page are you looking at?
The judgment?
Yeah.
Yes. I will read something to you, but let me deal with this.
That's the judgment you have?
Is it when? Yes.
Okay, that's why I'm asking which page you're, so that I can equally refer to here.
No, I just wrote something there.
Okay.
But when I'm about to read something,
please go ahead.
I'll aid you. When I spoke about the proceedings and said that it is always advisable in a criminal trial, and lawyers will know, to raise any issue of constitutional breach at an early stage. Now, we were done during the proceedings where there are rival meanings, and that is what we are taught, except somebody who doesn't want to be truthful. You refer when there are rival meanings. So let anybody tell me at what point during the proceedings or the trial that there were ever any rival meaning. Who said what and who said another? Do you get the point I'm making?
Sure.
Because if there isn't, if there is no conflict, there is no resolution. It is not you who go to sleep in your house and look at a provision and say, I want this referred, and you write in your closing address for the judge. That is not what the law says. The judge dealt with this matter. It's not as if he closed his eye. And let me read that to you now. That is page 14. The judge dealt with the matter. In fact, he started from 13 and dealt with, he raised the issue of the ex parte accosa, which is a guiding principle for every lawyer on whether a matter, let me even put this. Any lawyer that tells you that it is automatic, that once an issue of even constitutional interpretation is raised, automatically it must go to the Supreme Court, is not telling you the truth. I won't say it doesn't know. It's not telling you the truth because we have been taught that the guiding principle is ex parte accosa. There are things the judge should look at, whether it meets that, threshold for it to be referred.
Ambiguous or unclear.
Absolutely. So you don't just say because you sat in the comfort of your home and just assume that there is a provision in the Constitution that
you cannot sit down so that when I come back.
You just have to take the thing to them. They refer to Zanetto. Beyond Zanetto, go and read GHOne. The court said this practice of everything you refer, they thought they were doing us. That was what the Supreme Court said. That it is not every matter that should be taken to GHOne. Go and read that ruling. And that's the latest. So let nobody deceive you. If you want me to read GHOne, Google GHOne's case, what the Supreme Court said about referring matters to the Supreme Court for interpretation. So the judge dealt with it. And on page 14, here's what the judge said. He said that, he said a lot of things. Similarly, Section 14(1) of Act 703, as amended, sets out in writing and without any real obscurity the conduct it forbids, namely the transfer, assignment, mortgage, or other encumbrance or dealing with a mineral right without the minister's prior written approval. And it borrows its penalty again in writing from Section 99(2), because you see, when you look at the 14, the 99(2) is where, or 2B, is where the punishment is. They are just being it's just politics they are doing. They know. I know they know, pa. See, he said, whatever quarrel, listen to what the judge said, whatever quarrel counsel for first and third accused persons may have with the breadth or the wisdom of that legislative choice is not a quarrel about whether the words in the Constitution bear one meaning or another. It is at bottom a submission that Parliament ought to have legislated differently. That is not a question of constitutional interpretation. And I agree with the judge. Every lawyer would agree, except he wants to be political. Where is the interpretation? Where are the rival meanings? Tell me what the Attorney General's version of it is. That is where it comes in. Version of the constitutional provision. That you thought that if I'm saying this and the other side is also saying that, then we need an interpretation. Where did they happen? That's why he said that during the proceedings. Where did they happen? With GHOne, we know what happened. Because immediately GHOne was arrested, that matter of whether indeed, if you remember, the issue of at the particular time he should have tendered in his whatever, whether indeed he was even eligible or not. All those discussions were held. And then it happened that they took the matter to the Supreme. Even that, the Supreme Court said, no, it is not automatic that you should have come. Go back to the High Court. That is what the Supreme Court did under your watch. Since when did you realize that anytime the least, mention of any constitutional provision, every judge should? That is not what the law says. The Mekankan case, even the Zaneto case, they said that a judge would know, of course. But you have even mentioned. A judge will know what? Continue. A judge will know what?
No, you were mentioning.
No, we don't assume jurisdiction to interpret the Constitution. But that is not, he should decide. Let me read, for purposes, if he wants us to go there.
Okay.
Let me read what the decisions say. The Mekankan case, the GHOne case.
Okay.
They are all
Zaneto, you were quoting from Zaneto.
I said quote the latest, which is GHOne. Why are you running away from GHOne?
Okay.
Why are you running away from GHOne? That is the latest under your watch. Read GHOne.
Which page?
So this is GHOne, yes. Page 12. Read it to you. That's the latest, 2022. 27 July 2022. This is what the judge reproduced it here. The Supreme Court cautioned against the tendency of abuse of the reference jurisdiction. What are you talking about? GHOne, that is the latest in terms of, so if you throw all the cases and then deal with the latest, which is the GHOne case. This is what the Supreme Court said here. Yeah. And the court reproduced, don't you see it in the judgment? So how can anybody say that the judge didn't consider all this? That is the latest Supreme Court decision about referral. Okay. Let me read it again.
If you would indulge me,
Please hold on.
You would realize that ex parte Akosa gave, I think, 2 or 3 grounds where matters before a trial court can be referred to the Supreme Court for interpretation.
It's not 3. It's not 2 or 3.
How many of them?
You should.
So you can mention. So I am
But
telling
he
you that
says
what
2 or 3.
you have just. But he cannot give me the other.
So please list them.
So let me give you the one he is referring to. In reference to GHOne. So where the words of the provision are imprecise or unclear or ambiguous, put in another way, it arises if one party invites the court to declare that the words of the article have a double meaning or are obscure or or else meaning something different from or more than what they say.
Yes.
This is the matter that Supreme Court was referring to. Our case, using the ex parte Akosa, it's on the second ground.
Okay.
Which is where rival meanings have been placed by the litigants on the words of any provision of the Constitution.
So what is
Article 19, we've
by the litigants.
Article 19,
no, 11. You are still not. It isn't deliberate or something.
What is deliberate about this?
Please, then allow me. Let me deal with the matter.
What is deliberate about this?
Is it deliberate or something? Where the litigants place rival. What is the meaning? This is English. It's not law. Where are the rival meanings? What is the understanding of the Attorney General in this matter? What has the Attorney General said differently from yours? Where are the rival meanings? Why are you making a case where there is none? We know that you are only being political. My dear, because there is nothing rival. That is what there are no 2 different meanings. Your understanding is that Parliament did not do a good job the cure is not to refer a matter for a rival meaning to be determined. The cure. Why? If there is any law, and maybe I may profile, no, they know, but that's why I didn't want to go. If you realize that the parliament passed a certain law which breaches the constitution, the action is not under 132. The action is not under 132 because 132 deals with during proceedings where two meanings come up. It didn't happen here. Your lawyer, what's his name? The one who left before. Never made mention of this in court. Throughout. It was the end of it. That you on your own, in your house and in your comfort zone, raise the issue that there is a constitutional provision that ought to be looked at. There are no rivals. So the judge said this. Let me finish. Now, he said this, that...
But honorable, I think you should be fair to the public, the listening public, and the viewing public. Do not interpret the Constitution differently from what is written. The Constitution never mentioned that during the pendency of the trial. It said during the proceedings. That's the words. That's the words of the Constitution. And I don't know why. I don't know why. You are creating the impression. You are creating the impression in the minds of the viewing public that it is only when cross-examinations and all those trials is going on.
Do you know why you are still getting
this can be triggered?
No,
but that is not correct.
So you are getting
anytime before judgment. This.
So throughout the proceedings.
Exactly. Okay. That is what the Constitution is saying.
You are getting it completely wrong.
From what the Constitution is saying.
Let me help you.
Okay. So please allow him
to sit down.
So listen, if you listen, you understand. Note it. And please listen before. What I'm telling you is that the reason I refer to proceedings is that during that time, both parties, the litigants, should have different meanings. Throughout, till the time your people wrote to the court in the closing address, where was the rival meaning? What was the meaning as espoused by the Attorney General against yours? Show me. And that is why the Constitution refers to proceed, because if there will be conflict in terms of how I understand it and how you understand, it will be during the proceedings.
Okay.
So tell me at what point this ever came up and there were rival meanings. You know, you have been taught that where there are rival meanings, where are the rival meanings? What is the version of the Attorney General? There is none.
Okay.
So I'm saying that it is not you, and I've repeated it, except you don't want to hear. It is not you sitting in the comfort zone in your house to raise a suo moto without any conflict and raise it that there is a provision in the... I'm saying that there is a cure. If you on your own sat in your house, somebody has taken this third term thing to the Supreme Court.
Yeah.
Was there any rival meaning? No. So if you understand it, the cure, I'm saying that the cure to if you think Parliament passed the law which doesn't meet the threshold of Article 19(1) is not under 132, because 132 says that where during proceedings there are rival meaning. In this case, there is no rival meaning from anywhere. So the judge then tells you that you are using the wrong procedure. And in any case, even if, assuming without admitting that there are even rival meaning, the judge is guided by all the authorities, ex parte acosa. You admit, and you've said it here, that there are, you've said two, even if it is one, it means that it's not automatic. Do you get it? It means that the judge ought to evaluate whatever you are putting in accordance with that one or two you are talking about.
Okay.
So what are you talking about? Now, please, wait.
It looks like honorable.
Hold on.
No, wait. You also said something. See, when you say somebody is involved in galamsey, read the charges. You know, you've been taught that inchoate offense, abetment, is doing the same thing. So it would be if it was, listen, if it were a lay person saying that, I'll be shocked by a lawyer. Somebody who facilitates stealing is a thief.
And the thief himself is left off the hook. Is that what you're telling me?
You are saying
that inchoate offenses are not offenses in themselves.
Now,
so you
inchoate
conspire.
offenses are not offense in themselves. You can only abet with somebody. You can conspire with somebody. You can do all those things with somebody. You know, being in the scenario.
That is the point.
But what
that is what you see. We are doing this together, but you say I'm the one taking. Maybe you should listen.
Hold on.
The man took advantage of the plea bargain. It's not as if he went scot-free. You should know this. That is what the Attorney General is telling you. It's not as if he went scot-free. He said, yes, I'm guilty. But why didn't Wontumi do the same? He said he was innocent. But the man who was
That's why he offered to become a prosecution witness.
Absolutely. It was no prosecution agreement. And he said that I forfeit this, and they had a certain agreement.
Okay.
And so you can't say he went scot-free.
Okay.
The fact of the matter is that when you are charged for abetment, you are included.
Sure.
Why? Were we expecting to see Wontumi hold shovels and whatever? Look, your own government, let me end with this. It was your own government after 2000. If you read the 2006 Act, it didn't include the B, the inchoate. Your own government we thought that we needed the big fishes whom we will meet at the site. There was no likelihood of meeting the big fishes there. That is why we brought in the B. It wasn't part of the 703 initially, the 2006. Yeah. So read the B again and tell me if it's not related to Galamsey. Who is talking about? I've heard that and I'm surprised.
I think the B, we have read it.
No, let him read again because of the assertion you've made here.
Because it is eating into my time and I need to make.
So please land so that he can. Yeah.
So the B talks about the facilitation. So if you went to procure excavators, which is not used to plant coconut, excavators dig. If you went to procure earth-moving machines, if you ask somebody to go there, you are now deceiving the court. The court has ruled, so I can confidently say that, yes, you deceived the court. That you ask the person to reclaim without money, and you are saying a small-scale miner. If you didn't mine, what's your interest in asking, if coming from Ashanti region, are there no mine pits there? Why did you go to Samra Boy to go and reclaim? Okay. Who was supposed to pay for that? So the judge had a mandate to evaluate what was put before him. And he did it in accordance with law. At the bottom, if you disagree, I agree with you, go to the Court of Appeal. But don't make it look as if you have your own meaning. No intellectual will sit and say, I have my own meaning. When the meaning you read, who a political prisoner is.
Is the NDC worried about an appeal?
Why? I've said it here.
So.
Did you hear me?
So.
I said what you need to do is to appeal. When Ato Forson went on appeal, did you hear a press conference? So get me well.
Are you worried about a press conference?
What?
Are you worried about the press conference?
I'm saying that if you say that somebody is a political prisoner.
I asked the question. I needed an answer.
You say somebody is a political prisoner, at least, if for nothing at all, Google is there to help us. Except you are being intellectually dishonest. What is a political prisoner? If it is not, and the gentleman was charged based on our law, and you disagree with the evaluation of the evidence, the court of Mukramache, I don't know why you are still talking and we've not seen the notice of appeal.
Okay.
Under Article 11 of this Constitution, the 1992 Constitution, which is the supreme law of this land, we have hierarchy of laws. I don't know why Honorable is so fixated on ex parte Akosa, even though it is in his right to quote ex parte Akosa.
I quoted Chikwesi.
But hold on. I'm talking about the rival meanings that has been placed to the provisions for which he was charged. Let's look at the supreme law. If you look at Article 11, which I'm sure you have opened, you realize that the law of this country is the Constitution. Yeah. And the Constitution under Article 132 is very clear that let me read it again.
Read it.
Where an issue that relates to a matter or question referred to in clause 1 of this article arises in any proceedings in a court other than the Supreme Court, that court shall stay proceedings.
So what is the issue?
Hold on.
What issue happened?
Allow me, Honorable. What is this?
Please allow him.
Oh,
shall stay proceedings and refer the question of law involved to the Supreme Court for determination, and the court in which the question arose shall dispose of the case in accordance with the decision of the Supreme Court.
Clause 1 here talks about enforcement or interpretation.
No, even the two. Is that why there is an issue? What
do you know what this means? It means that the interpretation the Supreme Court would have given to Section 14(1) and Section 99(2)(b) of the Minerals and Miners as amended could have a very big impact on the judgment that was delivered by the
You are not getting it. You are using the wrong forum.
I'm not using the wrong forum.
No, you are.
The Constitution
I'm
is
saying
clear.
that No. He did it. Let me also...
Please.
Okay, hold on.
You did it. You did it. No, you didn't. At the point, I allowed you about 2 minutes to flow.
You gave me 2 minutes.
Yes. You see, what you are saying is not the case, because if you intend asking for the interpretation of any provision of the Constitution, you go not in the manner you are talking here. They said when proceedings, and there is an issue. An issue has been interpreted. You are a lawyer, you know that with the interpretation given by the
the judge.
The Supreme Court is the interpretation that is in the Constitution. So the ex parte Akosa, which was given by, you are a lawyer, given by the Supreme Court, is the guiding principle of the issue. The issue it raises, that conflict, where
ambiguous,
there are ambiguous,
and
those things, it's been interpreted. So if you go to the Supreme Court now, they will say, go back, we've interpreted it already through Akosa and then all that. So go and read it. So you don't leave the ex parte Akosa and come back to the Constitution, which has been interpreted.
Arrogating the work of Supreme Court onto himself.
It's been done already. You know this.
Please, and Honorable made a point, which I find a lot of NDC communicators equally making such points. That how do you ask somebody to go and undertake reclamation without giving the person
you are okay
the
with
person
the
money?
Interpretation.
But I have made my point on that, and I'm sure the listening public will have the benefits to judge who is making sound legal arguments in this one.
Okay.
What I'm saying is that there is a lot of false narrative out there that GHOne to me did not give any money to PW2 to undertake the reclamation for which...
If you say PW, that's prosecution witness. So that's Henry Okum.
Henry Okum. Exactly.
So that people
and what I'm saying is that, in our traditional system of farming, we have Abunu, Abasa, and all that. Ebusa and all that. You understand? In this judgment, there was no clear agreement, and the judge alluded to that there was no clear agreement or document to state that to guide the reclamation that GHOne to be directed PW to undertake. You understand?
But the Abunu and Ebusa system is not for agricultural purposes.
I am saying, of course, he was to plant coconut seedlings on the way, and is that not agriculture? Please. At this point, honorable, please.
No, he did it.
But you have interjected now.
Planting of coconut seedlings is not agricultural activity. You cannot tell me that.
I was about to assist you.
So you see, what shows that such an arrangement was not made, especially when the court itself has admitted that there was no agreement or document governing that agreement between PW2 and Akonta Mining Company. That is one leg of it. And I also find this judgment to be a miscarriage of justice because at all material times, it wasn't Chairman GHOne to me directly who was dealing with PW2. You understand? It was Akonta Mining. And the position of the company law, the guiding principle in company law is very clear that once a company is incorporated, the company is separate from the directors and shareholders. Even though I agree that there are grounds on which corporate veil may be pierced, but from the law we are seeing here, from the judgment we are seeing, what warranted the corporate veil to be pierced? So at worst,
and there is a crime.
What crime was committed? Was there? You agree that there was no
marriage matter they were there?
You agree that it was not direct. GHOne to me was not directly involved. You understand? So at worst, it is the company that ought to have been found guilty in the mind of the court. But you know why? The court knows and the prosecution knew that if the Akonta Mining was found guilty, Akonta Mining is not a human being who can be in prison. So at worst, it would have been a fine. But that is not what they were intending. They intended GHOne to be in prison.
They meaning the NDC? The
NDC, the prosecution, whoever. That was their ultimate aim. Otherwise, why would
the NDC is the judge.
The NDC in terms of the prosecution, of course, it is.
But it was for the judge to evaluate and give a decision. The judge has done so.
That is why we are saying that we have a problem with the judgment that was delivered. You understand? We say we have a problem with. So it's not a judge we are talking about. But it is a judgment. Exactly. So I feel that the corporate veil should not have been pierced under the circumstances that we have all seen in this judgment. So it was a wrong piercing. It was a wrong unveiling of the corporate veil. And at all material times, it was Akonta Mining that undertook the transaction with PW2. So why leave Akonta Mining? And in fact, in the judgment, you realize that some penalty unit was handed to Akonta Mining.
Yes.
You understand? But they found a way to actually rope GHOne to me in. GHOne to me was not directly involved. They roped him in because they wanted to secure custodial sentence against the man, which is clearly unfair.
Okay. Let me take a break. Let me take a break.
20 seconds. This is very important.
Okay.
Look, except someone who doesn't know. If you take a concession and you mine, it is what is beneath that you mine or your lease covers.
Yes.
When you are done, in law, the surface right is not with you.
It belongs to the state.
It belongs to the state. So for you to say that I asked somebody to go and plant coconut, it's completely out of place. You can't even say that. The surface right, that's not what you went for the lease for. So it is all lies. It is all lies. You don't even have that mandate. You ask for what is under. When you are done, reclaim and leave. But if you say that I contracted somebody and you are even talking about a bunu as if he went for surface right, and you prompted him that you are talking a Greek here. It's not mineral rights, because mineral rights is what is under. And you've taken it already.
Section 72 talks about the surface rights. And the 72(2) says, in the case of a dispute between a holder of a mining lease and the minister concerning the limitations determined by the minister under the subsection, the dispute shall be referred for resolution under section 27. Let me go to 27. Look at what 27 says.
It
says, where a dispute arises between a holder of a mineral right and the Republic in respect of a matter expressly stated under this act as a matter shall be referred to for resolution, all efforts shall be made through mutual discussion and if agreed between the parties by reference to alternative dispute resolution procedures to reach an amicable settlement.
My dear, it is right that you go for a lease with regards what is under for your viewers to understand.
Yeah.
You don't go for the surface right. It's not yours. So when you are done, you reclaim. That's what the law says. But you don't have the mandate to determine or to go into any contractual agreement with anybody to go and plant anything there. It's not yours. So anybody that tells you that in the court of law is lying. And it's clear after thought. That's what the judge said.
Okay. All right, let me take a break. When we come back, we'll do a bit of talk on the budget. Government has exceeded its 2026 budget targets. Stay with me. I'm back shortly. You're welcome back to the show. This is still GH Today here on GHOne TV, and I am Lily Mohammed. My guests are still here, Russell Usu Esquire and Bernard Bediakubedu Esquire. We've been talking about the Wontumi case. I have a few minutes to go. Let's talk about the budget which was presented to Parliament by the Finance Minister. That's a mid-year budget review. Government says it's exceeded its targets for 2026. Ross,
yes.
Were you convinced?
In as much as the Finance Minister and the government of Ghana try to, make the figures look good on paper, I must say that it does not reflect in the day-to-day living of the ordinary Ghanaian. And there are some comments I would like to pass regarding the mid-year budget review. You remember the troubles the NPP government had when they, did the debt restructuring, the domestic debt exchange program. Yes. In this budget review, the finance minister actually mentioned that the debt to GDP ratio has declined to 45%. But he failed to mention that this was as a result of the debt restructuring, because he knows that once he goes on that tangent, it gives credit to the New Patriotic Party, led by Nana Addo Dankwa Akufo-Addo. I must also mention that as a result of the debt restructuring program, which the NPP viciously embarked on to ensure that this economy was sustained, has led to Ghana saving almost 50% of its debt payments or debt financing. So we are to pay 111 billion Ghana cedis in 2 years to service our debts, as opposed to 230 billion that we would have been paying if it wasn't for the decision of the NPP administration to go for that debt restructuring. You must also take cognizance of the fact that the GHOne has made mention of the fact that they expected certain things to happen. The finance minister to mention and address certain concerns that he raised, about 4 of them. And only one was what the finance minister addressed. Under the mid-year budget review, were you not surprised that the NDC campaigned on the 24-hour economy, for which they were voted for into government? And throughout the speech given by the finance minister, 24-hour economy was never mentioned. Do you know what this means? What this means is that the ordinary Ghanaian has been shortchanged. The teeming youth of this country who are looking for employment, who were promised that there will be 1 job, 3 shifts, and 3 different persons will have access to that job. It cannot be materialized because the finance minister and the government of Ghana is clearly not interested in this position again. They only use it for political points. And now that they've gained those points, they don't care about the teeming youth. It is the case that from the Ghana Statistical Service, they mentioned, if you go to their website, you will find that unemployment has risen to about 13.0%. Unemployment stands at 13.0%. And in fact, youth unemployment is estimated between 22.5% and over 30% of young adults and graduates aged between 15 and 35 do not have jobs. If you have a country that the ages between 15 to 35, that comprises of your active population, do not have jobs, then what is the security of that country? You understand? Inflation stands at 5.3%. That is what we are told.
Yeah.
But look at the prices.
But is that not what is? You say that's what you are told. That's according to the Ghana Statistical Service that you mentioned.
When inflation is reducing, it must reflect in the ordinary living of the Ghanaian. True. So when inflation is reducing and it's not reflecting in my life, then what is the purpose of the figures coming down? That is the position we are trying to advance. So inflation being 5.3%, and I go to the market and I have to buy 50 cedis worth of tomato just to be able to prepare jollof for that dinner. Then what kind of country are we living in? When MPP was leaving power in 2024, December 2024, fuel was hovering around 15.45 Ghana cedis to 15.72%. Today, when I was coming, fuel is 17.41%, and some stations are even selling 17.67%.
For diesel?
For diesel.
Okay.
Of course, because that is the fuel that is used. All the trotros that operate in our country, it runs on diesel. You understand? So the petrol is for the high-end, persons like honorable.
But if high-end person is paying 14, how is a high-end person paying 14?
That is around the same. How much they are paying now is around the same thing we paid in December 2024. So they have not done anything dramatic. Let me also mention one key thing that the finance minister spoke about. Under the NPP, we went for an IMF negotiated program which earned Ghana $3 billion. Under this current administration, they are going for a PCI, policy coordination instrument, which comes with nothing, but because they don't have confidence in their management of the economy, they need IMF to supervise them to manage this economy. You understand? But when we were going for IMF, you heard the things that they said in Parliament, and I'm sure, at the time he was not in Parliament, so I cannot fault him for that. But his colleagues in Parliament, you heard them when they were making allusions to the IMF program. Now, we have a country where we were promised that about 8.6 months of import cover is what we are going to attain this year. And it has turned out to be false, that the 12.94 billion gross international reserves can only translate into about 5 months or less of import cover. So as we sit in this country today, we don't have the hope that this government can deliver on the promises that he gave us. The youth of this country do not have jobs to do. And it is obvious when you go to the streets of this country, and in fact driving here, you see active youth of this country who should be engaging their energies in positive ventures are all over the street because there's nothing for them to do. You understand? And this is a worrying situation. And if this administration does not sit down to look at some of these problems, it's going to raise security concerns in this country, because we cannot have a country where majority of your youth and your teeming population are on the streets without work to do. So this is a problem that we expect that the NDC government will actually be working towards. So having said that, I'm sure that the ordinary Ghanaian is disappointed in the government of John Dramani Mahama, and I have no doubt in my mind that come December 2028, they will make the right decisions to take this government back to where it deserves.
That's all. Why are you laughing?
Interesting, isn't it?
How so?
So fuel is
17.14.
For diesel. It's not 22 yet.
Not yet.
But did we ever get to 22?
Yes.
Oh, okay. Under the tenure?
Yes.
Thank you.
At the time of leaving government, what we handed over to you was not 22. We handed over a far lesser amount to you when we were leaving government.
Hey, these people. You see, he's talking about unemployment. In fact, that's for the fuel matter. I don't want to go into how they messed up the energy sector. They messed up. What is the current state of doomsday? How do you say it? Do you hear them say it again? Thank you. How they messed up. But he's talking about unemployment. We don't have time. I'll just be mentioning unemployment. At least in the first three quarters of 2024, unemployment, according to Ghana Statistical Service, was 13.7. The minister quoted it. So if today he's saying 13.0, it's better than what we even inherited. It's better. That's a fact. So you don't come today and tell me there are people in the street. During your time, everybody was working. This is the hypocrisy with which we do our politics. 13.0 is far better than 13.7 you gave us. Look, as for the macro, it appears they've all come to the realization that this government is doing well. So their point is that it doesn't reflect in our pocket. Don't you hear that narrative? So the macro, the GDP, the inflation, what they understand that the government is doing well, but they are underscoring the importance of macro. Dr. Baumia, whom they pray for, that he becomes the president of the country, which I don't ever wish, said this in February 7th, 2024. Okay. On February 7th, 2024. This is the caption. Bawumia outlines decision to ensure macroeconomic stability if elected president. There are a lot he said. But let me just give a quotation, direct quotation. A major goal of my government will be to attain and sustain macro stability with low inflation. Is inflation low or high? Help me, my dear. We are doing this together.
5.3.
Is it low or high?
It's low. Thank
you. This is Dr. Bawumia talking in 2024. Low interest rate. Is it low or high?
It's low.
Exchange rate stability. Is it or it's not? And low budget deficit.
What is the impact of this in the life of the ordinary Ghanaian? That is the point we are making. This is the point we are making.
You see, when the thing hangs on your neck, you try to escape. You will never escape. This is
when
inflation
was 23%. We were paying far less for electricity and water.
Ross,
now inflation is 5.3%. We are paying more.
Cancel. He was quiet when you were speaking.
Where lies this argument?
Dr. Bawumia in 2024, I repeat, said that his main goal, I've quoted it to you, except you dispute it, as a president, if elected, will be what I've told you. Let me say it again for it is hypocrisy and politics they do always. He said his main goal as president. I'll say it again, whether he wants to hear it or not. A major goal of my government will be to attain and sustain macro. You didn't say he will go and send money to every Ghanaian. That's not what Dr. Bawumia said. So if you believe in him, you will not come here and castigate President Mahama.
Okay.
Will be to attain and sustain macroeconomic stability with low inflation. I'm asking you, what is the current inflation rate now? With low interest rate, is it or it's not? Exchange rate stability, is it? And what even makes him, I don't want to, I respect him so much, so I don't want to, is that he couldn't do it as the messiah of the economic whatever during the 8 years of his era. But he now said that when I'm voted to become the president, I'll do these things. We are already doing it. And it's a fact.
But their concerns are, how does it reflect in the pocket?
But Dr. Bawumia knew that it will reflect. That's why he said that would be. Because,
answer the question. It's a legitimate question.
Because every government, nowhere in any world, would you see government doling out money. You create the atmosphere. Sure. And that is the economic indicator, except you don't know. You create the economic, situation for businesses to thrive. So people can get employed. And that is what you do. For a business, if you have investors who will come and invest in your economy, they will look at this. That is why I'm saying Dr. Bawumia knew what he was saying. How is your stability in terms of your inflation? Your stability in terms of your exchange rate. This is what the government ought to do. No government, nowhere in the world does it dole out money. So, having inherited an economy and messed the economy like you left behind, who can ever, implement 24-hour economy in the first year? What is 24-hour economy? We need to employ people, pay them. Where was the money? Where is the money?
But that is what you promised.
Yes, and we are working, so they should keep quiet. Because
how long should Ghanaians wait?
No, wait. Look at the budget. These are the things. Let me even tell you some of the things we are doing. Look, we are constructing a 1,200 megawatt state-owned power plant. You know this. This is the president who thinks far ahead. He's the same person, himself and Professor Mills, may God bless his soul, who brought this gas plant at Wabo. Yes, to come, we'll still benefit from it. We are still doing this. Because that would, you see, and listen to what the government is saying. Government is deploying 1,200 megawatt state-owned combined cycle gas-fired power plant at Kofajiji, Didi, Abromia, no, in the Commander Iduna Iguafu Brim municipality. The first 600 phase will be expected to be commissioned in 2028. The project will reduce electricity tariffs by 10 to 20%. Okay. Isn't that good news?
It is, but I'm asking on the 24-hour economy, which you campaigned on the back of. Because anytime you saw President Mohammed's billboards, banners, one of the critical things you see was 24-hour economy. We are 2 years. This is the second year of your administration. We are not 2 years yet. No, I'm saying we are in the second year of your administration. We have not seen evidence of the 133 that you promised us. We have seen pockets of it in some state institutions. I was coming
to that. So, except you are being dishonest, at least pockets.
And the pockets she's talking about is the breaking down of schools and building markets.
Who told you that?
That's what is happening.
Go and find out from the passport office.
Well, yes.
Is it true or not?
Ghana Publishing.
So what do you
PSC
want to hear?
Shipyard.
The court is being done. You are a lawyer. The Chief Justice have given a roadmap. You know this. Except you don't want to be truthful. What else were you expecting? But we cannot. Look, in building a country and inheriting economy as messed as you did, we will not just throw out anything.
An economy that provided free senior high school education was messed up. Is that what you're telling me? An economy.
You still talk about what you left behind.
Please land. So I have to close. Please land for me.
You see,
in fact, if you let me help you, this budget fell short of even mentioning the 1 million coders program.
Does this man really understand what the media budget is?
The big push. You realize that they were to pay 70 billion Ghana cedis to contractors. They only paid 6.5. They've only paid 6.5 million, and now contractors are leaving side. So the big push is no longer pushing. Now, are you not surprised? Are you not surprised? Are you not surprised?
Listen. No, please. It is not true.
This budget, they are leaving side.
You don't know.
It's clear.
Tell me which side. Don't just come and peddle for us. Tell me which road a contractor is.
From your own finance minister.
Tell me which road. You don't come and just spew. Which road does a contractor left? I've asked the question. Answer. It's not reason. Answer. Don't come and lie.
And you're only paying 6.5 billion.
I'm asking you which road has a contractor left side.
You cannot come here and tell us that the big push is ongoing.
I'm telling you that big push is ongoing. Every contractor.
Where?
No contractor is owed.
No contractor is owed.
You don't owe big push. But that's what the finance minister.
What are you talking about? What is this?
No, now, do you even know your economics?
Honorable.
So let me help you.
Please
listen to me. Now let me tell you.
Please allow him land.
When a budget is raised, you don't pay every budget. You raise certificates and take. Do you know this?
But this is mid-year.
Mid-year. The money saying that
you have not even done half.
Oh, please.
What are you talking about? Don't go there, please.
The 70 million.
What are you talking about? For another big push. To pay for payment of contractors.
Payment of which contractors?
Okay.
The man is telling you that
what are you talking about?
Any contractor that has raised, haven't you heard this? Raised the necessary or requisite certificate has been paid.
I'm not surprised.
So tell us. You see,
is it not under this administration?
Which certificate
that
has
the
not been
finance
raised
minister?
Ask him.
No.
Ask him.
So is it not under this administration that the finance minister told this Ghanaian public that he has advanced a certain amount of money to the agric ministry?
Look
only for the agric minister to come out to say that.
You don't run away from the big push. Don't run away from the big push. Tell us which road. You don't know. You are saying you are just making.
Are you not surprised I did not talk about any growth strategy?
I'm surprised. You know what the media budget is.
You have stabilized the economy.
Does he know what the media budget is? Do you know what the media budget is?
But do you know what the media budget is?
I'm surprised.
I'm surprised you are here and you are not admitting to the facts mentioned and alluded to by your own
All right, gentlemen.
Which road has had the contractor?
Thank you. That's Bernard.
I don't need your time.
I don't need your time. Okay, Bernard is the member of Parliament for the good people of Akwetia, and Ross Owusu Esquire is a member of the NPP Legal Directorate. And my name is Lily Mohammed. Thank you, gentlemen. I take a break. When I return, we'll do some health as well. Stay with us. You're welcome back to the show. This is still GH Today here on GHOne TV. I am Mohammed. If a young person who is interested in entrepreneurship, please lend me your ears for the next couple of minutes. This morning, I've been joined by some representatives from the University of Ghana to teach young people how to fund their dreams and how to tap into entrepreneurial knowledge. My guest this morning is Hilary Philippanyako. She's UG SRC General Secretary. Phelps Mule is a team lead, Fund Their Dreams, and Franklina Efrie is team lead for Fund Their Dreams. Good morning, ladies and gentlemen. How are we doing?
Good.
Okay. So if we talk about Fund Their Dreams, what does it mean?
Okay. First of all, I want to give a brief about what Fund Their Dreams is. So somewhere last year, when I was aspiring to be the SRC General Secretary, I identified a challenge. We realized that most students have good business ideas, but how to actually shape these ideas and nurture these ideas was actually a problem. Then I promised myself that I would bring all of these people together, give them a network, a training, and I know it might not be the spotlight moment for them, but it could be
What are some of the businesses you identify these students were venturing into, and what critical things did they need?
I realized that food is something most
Philippa, kindly hold on for me. Unfortunately, you are inaudible, so people cannot hear you. So let me hear from Franklina on Fund Their Dreams and what you're doing for these young people in schools.
So as at now, we are just trying to make sure that we give them a platform where they will be able to tell us what their dreams are about. Maybe if they've already started something or they are engaging in a particular business at the moment, and find out what exactly they feel like they need to boost their business, or maybe to fund whatever vision they have in mind. And that's the whole point of Fund Their Dreams, is to push students, not just for you to come into the university to feel like after university, what else will you do? You can also start something on your own, and then after university, you will not just be at home waiting on someone to call you for a job, but you will start your own work. And then we are seeing to do that for our students, and we are hoping that it becomes very great.
Okay, Phelps, for the young person out there, what necessarily do they need when they are coming for Fund Their Dreams? What are you specifically doing for them? Are you giving them funds? What are you doing for them?
Okay, so currently we have about 110 applicants. The whole end game is to select a final 10.
Oh, so out of 100, just 10. A lot of people will be heartbroken.
Yeah, so it's not only this year. We are hoping to expand across, let me say, all universities across the country, but we are starting from our grassroots.
Okay, University of Ghana, yeah.
So the final 10 will go under a 6-month training from expertise who would give them much knowledge on not only how to start up their business, but also how to grow it, moving forward. And
the 100 participants that have applied, right? How did you select them? Did they apply through a particular medium? And the pruning process, what criteria are you using for the pruning process?
Okay, so I think that, well, the 100 participants that applied, we sent out a link to the various platforms. We sent out a link to various platforms for students to apply. So we started this about 2 months ago.
Okay.
Where we were planning everything, making sure that we have
so
everything.
You sent a communique to the entire student body.
Yes,
okay.
please. So we sent that to various platforms, to people that we felt can push this for, so that no one will miss it. So we sent it across board, and then various students applied through Google Forms. And then through the Google Forms, you see that we have a a section where you some way somehow pitch what exactly your vision or your business is about.
Okay.
So when you do that, so we have a certain criteria. I want to see what your business plan is, how you see your business to like help people across board, not just you yourself, but to also make an impact in the country. So we are not just looking at it as something simple. So we actually selected them based on the vision they have for their businesses or perceived business that they want to have in the future.
Now, Hilary, back to you. You're talking about what you envisage and all that. Yeah, please go ahead.
So I mentioned that the whole game plan is that in the years to come, University of Ghana and all institutions or tertiary institutions will produce entrepreneurs that have been able to survive the order of the day. We realize that many students have great ideas, and we can attest to the fact that most of the entrepreneurs in Ghana started from their schools.
That's
we
true.
have Chicken Man, and to mention, we are a lot. So if just imagine all of these students being mentored, being trained, being guided, and being ushered into an atmosphere that is very ready for them as entrepreneurs. It will not just build the country's economy alone, but also it will promote entrepreneurship on a larger scale. Looking at the fact that right now it's very hard for someone to get a job, starting your own job and having that support, having that platform is the deal for us.
What will you look out for in selecting the final 10?
Okay, so the first thing is creativity.
Okay.
Second thing is innovation. The third thing is how realistic the business is. We realize that, and the last thing I want to mention is the business structure. We want to know how structured your business is. Some students just have a business, but they don't have a structure on how their business is going to be like. So these 4 things are the criteria for us. However, we're not doing it alone. We have our lecturers, and we have some team members or panel members who are joining us to select. So then it doesn't become biased or because maybe you are a friend. No, we are very strict on the people who are going to be selected for the pitch.
You have a conference coming up. Okay, so these people will be at the conference. What are they doing at the conference specifically? How are the mentors impacting them?
Okay, so the first thing is that we give the mentors very, let me say, realistic things to speak about.
Okay.
For example, how to start a business from scratch. I know that if I give you such a topic, you don't come and tell me that I started with this 2 CDs or 3 CDs. No, but you rather tell us practical ways to
The
raise
truth
funds.
on ground. Yeah.
Right. And that is the whole idea. We are looking at them being very honest with our audience and participants. But I forgot to mention, we have 2 types of participants. We have those who are the audience, and we have the entrepreneurs who are going to be participants. So for the entrepreneurs, currently we have 111. Let me correct that. And for the participants, we have over 300 people coming to observe, or as they are our audience. That's what I can say.
Okay. So how many mentors are coming for this conference? It's a 2-day conference, right?
Right. We have about 10 mentors.
Okay, who and who?
So we have Dr. Kofi Abad, we have Magdan, we have Miss Rashida Sani, we have Mrs. Kezia Sani, we have Anthony Jamefe, we have Honorable Amankwa, we have Honorable Nane J. Bafwewa, we have Miss Kezia, and we even have great people who are also doing well in, let me say, lifestyle and like at large, who will be joining us to share tips with us, but they are not actually on the flyer. And I believe this will impact a lot of students. The whole idea is that we are impacting them, we are empowering them. I believe an empowered young person has the potential to change their society. That is the whole deal, and we know that it's going to be great.
Magdalena, when is it? So what time does it start?
So, God willing, it will be coming off tomorrow at 9 a.m. at the ISA conference on UG campus. So we would advise that everyone will be seated and ready to get impacted.
Oh, so why should anybody be there tomorrow? Is it open to the public? Do I need to register to attend?
No, please.
It's open to the public. Anybody at all can attend. And why should I be there tomorrow?
I would say there are a lot of influential people who will be there tomorrow. So anyone who has that mindset, maybe you don't want to start a business now, maybe you don't know, you never know. So just show up. Show up, yeah.
Okay. Philippa, your final words on why anybody should be there. And after the conference, then what next for these people?
Okay, so after the conference, we are taking them through a 6-month training. Those who actually prove that they actually need support, we're going to grant them. For those who haven't registered their businesses, we are going to help them register their business at no cost. We are going to take them through a 6-month training. When they are done with the 6 months training, we look at sustainable means of putting them all together to help their business. And right now we have tutors who are willing to help them solicit for grants from international donors. So the whole idea is that we want it to be sustainable and we want to measure their impact as well. So why I want everybody to be there tomorrow, I believe that everybody has a starting point. Maybe for some entrepreneurs it's going to be tomorrow. Maybe for some they might not know. But I'm very certain that tomorrow many lives are going to be impacted, many people are going to be empowered, many people are going to be, let me say, encouraged to start that business or to begin that venture. The theme is from vision to venture, empowering student entrepreneurs through innovation, creativity, and access to finance. So the whole point is that when you come, we are likely going to do giveaways, we are going to give souvenirs out, and also we are going to do spontaneous. Some of our speakers have mentioned that they are willing to get spontaneous direct mentors, like one-on-one mentorship. Okay. So we are looking at all these spontaneous sessions and we look forward to seeing everybody there. You don't have to be a University of Ghana student before you come. You can be, so far as you are Ghanaian, you are warmly welcome.
Okay, all right. So that's Hilary Nyako, Hilary Philippa Nyako. She's the University of Ghana SRC General Secretary. Phelps Mole is the team lead for Fund Their Dreams, and Franklin Efi is also a team lead for Fund Their Dreams. Tomorrow, I'll love to see all of you at the Easter Conference Room at the University of Ghana. See you. Let's do some celebrations now. You are welcome. You're welcome. Happy glorious birthday, Mrs. Gladys Abnaboni. The Lord has been faithful to you for 50 years, and I'm grateful to walk this journey with you. May this new decade bring you more joy, health, and favor. I love you more every day, from your husband, Mr. Bonnie. Hey. Happy birthday, Louisa Cassia. Wishing you a year filled with God's favor, good health, endless joy, and remarkable success. May all your dreams come true. Have a wonderful celebration. Happy birthday, Smile. May your special day be filled with laughter, love, and unforgettable moments. Wishing you abundant blessings, happiness, and success in the years ahead. Enjoy your day. Happy birthday, Akosiasa. God bless this new age, grant your heart's desires, and cause you to prosper on every side. Today, you have added another candle of knowledge and wisdom to your life. May it give you the power to enlighten the whole world. On your birthday, I wish you joy and happiness. Happy birthday to you, Felicity Sewa, a.k.a. Queer Red Pen from Sami. Happy birthday to my beautiful soulmate, Amabra Kwampofo. Life is brighter and more beautiful with you in it. This is from Nana Kwame. Happy birthday to Mrs. Jacqueline Obing Anson Esquire of Sun Lodge Hotel and Senior Presbyter of the Presbyterian Church of Ghana, Kaneshi Congregation, from ASP Amwa Richard. Happy birthday to Madame Estella Shandoff Ayebiakwa, alias Kakra of Presbyterian Church of Ghana, Kaneshi Congregation, Women's Fellowship, Akwa, from ASP Amwa Richard. I hope this is not the mother of Shandoff, Bakwesi Shandoff. Happy 60th birthday to an incredible father. Today we celebrate not only your milestone birthday, but also the amazing man you are. Raising triplets is no small feat, and your love, strength, patience, and dedication have been a true blessing to your family. Thank you for the sacrifices you've made and the values you've instilled. May God continue to bless you with good health, joy, and many more years of business. Happy 60th birthday. You are deeply loved and appreciated from Randy, Reynard, and Rodney. This one is a special one. Happy birthday to you, Henrietta Lois Martinson. God bless you incredibly, love. I wish you nothing but the very best in life. I love you always. This is from your Babu. Yeah. Babu wishes you happy birthday, Lois. We all love you. The entire team, we love you. Yeah. Happy birthday to my dear wife, Mrs. Hannah Benewa Amon, a superintendent enrolled nurse at Tafo Government Hospital. I thank God for this wonderful day and a new chapter of your life. May God remember you and let all that He has said about you come to pass. May you live healthy, long life to enjoy the fruit of your labor. I love you and will always be there for you. Thank you for being my life partner. This is from Theophilus Amo. Happy birthday to my beautiful, lovely daughter, Madan Shida Kwe. May God protect you and God bless you in everything you do. Daddy also loves you so much. From your lovely daddy, John Okokwe. To the man of the moment, today is the Enjoyment Minister's birthday, Rubian Kadem. Happy birthday to EIB's Terry Deborah. Cheers to another chapter of purpose, peace, more money, more enjoyment, good health, and unforgettable moments. The best is yet to come. Happy birthday to you, Terry, darling. We love you. We appreciate you. You are such an invaluable member of the team. You are quite stubborn, but we still love you. Happy birthday, my love. Happy birthday to you, Terry Deborah. Today, dear, party after party. That's it for the celebrations. We are marking a birthday today, by the way. Happy birthday to you, marking any significant milestone. Congratulations to you. Let's talk about health. You're welcome back to the show. On Health Alert this morning, we talk about hepatitis, and I've been joined by some students of the University of Ghana Allied Health Students Association. This morning, I've been joined by Nazir Mohammed Yakubu, Hefzi and Ifriye and Nihad Jaffa Swala. Good morning, ladies and gentlemen. How are you?
You're fine by God's grace.
Now, let's talk about the University of Ghana Health Allied Association and what your role is in allied health.
So, University of Ghana Allied Health Students Association, we represent the School of Biomedical and Allied Health Sciences. So, we are made up of physiotherapy, medical laboratory sciences, radiography, dietetics, occupational therapy, audiology and speech and language therapy. So, that's basically the courses that are offered under the School of Biomedical and Allied Health Sciences. And we seek for academic excellence, health advocacy, and all that. So basically, that's University of Ghana Allied Health Students Association.
Okay, let's talk about hepatitis. For many people, when they hear hepatitis, the first thing that comes to mind, hepatitis B. But I know there are other hepatitis as well. Kindly help us understand the various hepatitis that there are.
Okay, thank you so much. So hepatitis, actually, there are 5 different types, A to E, actually. And B and C are the most common ones. And I think they were named because of the times they were invented. Okay. And also they have different ways by which they are being contracted. And that's how come we have the different types of the hepatitis.
Okay, so walk us through the various hepatitis, the symptoms, how somebody, is it even preventable? So if I take hepatitis A, for instance, how can somebody know that I have hepatitis B? If I take if I take B, how can I know? If I take C, D, and E, and then are all these 5 preventable?
So with the different types of hepatitis, the main difference is how they are being transmitted.
Okay.
So for A is by blood, for B, C, and D is by maybe not just blood, but then through contamination, contacting with
an infected
substance.
person.
Yes.
Okay.
And also razor blades, contaminated razor blades, and sharp objects like that.
Okay.
So the main differences are how they are transmitted. But then with the symptoms, they all present with the same symptoms.
So let's look at the symptoms of all.
So with the symptoms, hepatitis is one disease that's, when it starts, it doesn't. The symptoms are not shown. You don't see the symptoms. They're usually called the silent disease. So in the early stages, you don't really see the symptoms. But as the disease progresses, you start to see symptoms like fatigue, nausea, vomiting, pain, and when it gets to the chronic stages, we have jaundice. So you have yellow eyes, yellow skin, itchy skin, and it also affects how your activities of daily living goes by. So yeah.
What are the myths and misconceptions about hepatitis?
Okay.
Is it treatable?
Yes, it is.
All the 5?
Yeah, they are manageable. Some of them are manageable. And for hepatitis, just to say, it's mostly best with prevention instead of like waiting till the end stage. Yeah.
Okay. You have a week of celebration coming up.
Yeah,
when
we
is
do.
it? And how do people get involved?
So it's Ugasa Week. It's themed Ignite, igniting connections and inspiring excellence. So the week starts today, and as part of the week is our media outreach today. That's why we came to GHOne to talk about hepatitis. It's part of the week. So it's a whole week from Monday to Saturday. We have a lineup of different activities throughout the week. Rep your school, debate competitions, Y2K. We have, and we also have the final one, which is on a Saturday, which is at the University of Ghana Sports Stadium, where we organize games and activities for students to be able to participate and, take time off, studies a bit.
Is it something that is open to everybody, or
Yes.
is just for students of?
It's open to everybody. It's
Okay,
open to everybody, so everyone can come and partake in the activities.
Why should anybody be wary of hepatitis?
Because most of the time it's asymptomatic. That's the symptoms is delayed. So you really know that you have it until you get tested for it. And maybe by the time the symptoms will start manifesting, it has already got into the points where there are complications and there have been a lot of damage caused already.
Yeah, I think it's easier and it's best to test